for joining us. My name is Daniel O'Neill. I'm the chair of the HYLA committee this bar year. We have an amazing topic, recent verdict trends in civil litigation, which is being presented by two fantastic lawyers and speakers. We've been looking forward to this for a very long time. So let me go ahead and introduce the speakers and we'll get this underway. Ericka Medina defends companies and individuals in tort claims. She has experience defending a wide variety of claims in areas including products liability, wrongful death, survival claims, personal injury, and professional liability. She has also defended grievances on behalf of attorneys filed with the Texas State Bar. She's a graduate of A&M undergrad and UH Law. Sofia, Colorado practice primarily focuses on coverage litigation and commercial property disputes. Her practice includes defending commercial carriers at various stages of litigation, as well as pre-suit evaluation of breach of contract and statutory bad faith claims. Sofia has experience drafting pleadings, preparing motions, and researching complex legal issues. Sofia is also a certified mediator. She's a graduate of UT undergrad and South Texas College of Law. Thank you all so much for joining us. Just quick housekeeping for everybody. If you all have any questions, go ahead and put them in the chat and they'll get addressed throughout, or you can put them in the Q&A box. And with that, I'll turn it over. Looking forward to this excellent presentation.
Thank you, Daniel. Thank you for that introduction, and thank you for putting on the CLE. I'm going to go ahead and share our screen just so you guys have something else too, something more interesting to look at. Here we go. All right. Like Daniel mentioned, we'll be going over recent verdict trends in civil litigation, specifically this trend of the nuclear verdict. We'll be talking about what a nuclear verdict is generally, how we're defining it in this presentation, what are some of the tactics and strategies that we believe can lead to these nuclear verdicts, and some notable verdicts here in 2021 that we've seen in Texas.
So to start off, we wanted to give you all a little background on what are nuclear verdicts. So this phenomenon has been coined by the insurance industry, and it kind of encompasses all the unexpectedly high verdicts in the past 10 years that are over $10 million or more. And these verdicts have skyrocketed and have kind of gotten the attention of media and other litigators because they have increased over 300%, with the average truck collision increasing from 2.3 million to 22.3 million the past decade. And from 2012 to 2019, the increase of cases of these nuclear verdicts have increased by 235% in cases over $1 million. So I think that the most impacted industry is the trucking industry, which has also been impacted by these nuclear verdicts. And according to the National Safety Council, just over 5,000 large trucks were involved in fatal crashes in 2019, which is a 43% increase in 2010. And the number of injuries associated with these truck crashes rose by 7% that year, and totaling to 160,000, with the majority being occupants of other vehicles. In a study published by the American Transportation Research Institute, the size of these nuclear verdicts severely outpaced the rate of inflation, with the rate of inflation being about 1.7% and the gradual increase of these verdicts being 51.7%, and the increase of healthcare costs about 2.9%. So it definitely outpaces the rate of natural inflation in our economy, and has really drawn the attention of lots of insurance industries and trucking industries, as well as lawyers throughout Texas. Although the term nuclear verdict is new, the actual phenomenon is not new. In the 1990s, they called this phenomenon the runaway jury. And Liberty Mutual recently published an article kind of giving a bit of factors and causes of these nuclear verdicts, which may be attributed to corporate mistrust, which is pretty much a poll, the Gallup poll, which says that Americans have little or no confidence in big business, so they're very eager to show that through large jury verdicts against them. The growth in litigation financing and third-party litigation financing. Several hedge funds now are largely invested in litigation and in financing litigation in exchange for a portion of the proceeds at the end of the verdict. Another factor is social pessimism and jury sentiment favoring plaintiffs. So this can originate from the majority of people believing that the system and bureaucracy is not working for them. And so they shift their trust to what they can control, which is, in this case, the verdict and the size of the verdict. Another reason and origin for the nuclear verdict may be the ability to quantify human life, and a rationale called the willingness to pay, or WTP, is an approach of how to quantify the monetary value of a human life by using rescue and medical service providers and seeing how much they'd be willing to pay to save a life.
Now we're going to go over some of the tactics and strategies that we believe are behind some of these nuclear verdicts, one of them being the reptile theory. Now, the term reptile theory goes back to the 1950s. It was coined by a neurophysiologist, Paul D. MacLean. What he basically proposed is that the human brain has certain divisions in it, different brains that within the human brain, the mammal brain, the reptile brain, and each deal with different types of emotions. The reptile brain, he believed, dealt with fear, kind of fight or flight, community protection, those types of emotions. This psychology theory was put into the context of litigation around 2009. We saw this book, the 2009 Manual of the Plaintiff's Revolution by David Ball and Don Keenan. Some believe that these nuclear verdicts, we are really started to see them more often since 2009 because of the publication of this book. The book basically translates how to use the reptile theory and put it into litigation practice. Putting it into practice by focusing on the corporate defendant, using kind of this maskless, faceless entity as the enemy, not the defendant driver or the defendant person, but kind of this amorphous being. Plaintiff attorneys can also utilize the reptile theory by painting the corporate defendant as a rule breaker. During discovery, during depositions, plaintiffs have identified certain rules, not necessarily statutes or pre-existing rules, but just general rules that everybody would agree with, that nobody would really disagree with. Things like, well, if you're trying to avoid a collision, don't go into incoming traffic. Everybody can agree on that. Then they would take this presented rule, have the corporate defendant agree with the rule, and paint them as a rule breaker in front of the jury. Culpability is much easier to be assigned when somebody's seen as a rule breaker instead of having to be qualified as reasonable, not reasonable. So it clears the line a little bit instead of them being more blurred, it's more black and white. Another reptile theory tactic is broadening the scope of the litigation, broadening the scope of what's at stake. Not only are the plaintiff's injuries at stake and the plaintiff's future, but rather it's the community at large, calling on that fear that the defendant's acts and those actions are putting everyone at risk and putting everyone at the jury, kind of appealing to that sense. This is somewhat different from the golden rule that was utilized in the past. The golden rule would basically ask the jurors to put themselves where the plaintiff was, to feel sympathy for the plaintiff, to feel for the plaintiff. The reptile theory, instead of asking for sympathy, asks for anger and asks for kind of knee-jerk reactions and fight or flight reactions, independent of what the plaintiff went through. These theories in general tend to serve the jury, not so much the judge. They tend to focus on the big picture themes of the case, not so much on the little details which the defendants usually focus on and try to preserve for appeal. Another big factor of this reptile theory is calling the jury to send a message, empowering the jury that they can have an effect and repercussions outside of the jury room, outside of that trial, and to send a message not only to the defendant, but to the broader industry. So that's very, very prevalent in these nuclear verdict type of cases. Another, oh, actually, I'll go back. The last thing is just some defenses that can be used against these reptile theory tactics, or just how they can be addressed in a trial. Is they definitely need to be brought up front and center. They will be in play, so ignoring them will not do anybody any good as far as the defense goes. Defendants have been seen to focus on the standard of care, making sure that the jury knows the standard of care is not the good of the community or safety standards, but rather what's actually presented in the jury charge, trying to get some of these themes out in a motion in limine, putting the judge on notice that these themes will be recurring in the trial, and that plaintiff might well want to get some of those themes front and center to the jury. Having plenty of rebuttal evidence. If defendant's being painted as a rule breaker, the defendant wants to have plenty of evidence that shows it is a rule follower to kind of have another storyline there. And kind of putting the jury on notice of what the reptile theory is and what the tactics are during defendant's opening and closing. The next strategy or tactic will be the anchoring bias. This anchoring bias I found really interesting because it was seen across not only the law, but real estate, negotiation, settlement, just across industries. And what it basically is people's tendency, or human tendency, to hold on to the first piece of information that we're given, to the first number that we're given, and make our decisions based on that number, even though that number may be completely irrelevant to what we're being asked. For example, people were given, there were two groups, they were giving a small number, number 2, number 3, and the other group was giving a big number, number 20, something like that. They were then asked to price different bottles of wine, and the group that was giving the smaller number would on average price them lower, and the group that was giving the larger number would price them higher. Studies have gone on to look at this in the context of juries, and they found that basically they had 56 mock jurors. One was given a smaller ask. The plaintiff asked for $20,000. The other group was giving a higher ask. The plaintiff asked for $5 million in damages. It was the same case that was presented to them. And what they found was that the group that received the smaller ask gave smaller awards, and the group that gave the higher ask gave higher awards. And this was true even when the jury believed that the number that was being asked was too high, or even when they disagreed with it, they still awarded higher damages. What was really interesting is that this seemed to have an effect on causation as well. The group that was given the smaller ask tend to only give about 25% confidence that the defendant caused the injury. And the group that was giving the higher ask was 43% confident that the defendant caused the injury. So even these, how much the damages were, tended to have a big impact on how the jury viewed causation in the case. Some defenses against the anchoring bias, some have suggested to provide a kind of like a counter anchor to give a different number. Another defense is the effect of the initial anchor tends to lower or be reduced when there are more variables inserted into the issue. So the more complicated things are, the more things that the jury has to look at, the less that number has an impact on the final decision. We also want to talk about the changing demographic of the jury. With millennials now being about more than half of the population in the US, they are also about 60% of the nationwide jury pool. The millennial generation is the most diverse generation. They have a big emphasis on technology, something that maybe the legal profession is a little bit behind on several surveys. Millennials have been questioned about how they like to see cases presented, what they like to see at trials. And they all agreed that they want to see graphic presentation software. They all agree that they want to see timeline software to explain the case. They all agree that attorneys should use technology to present the case. And they also all agreed that if a witness is not able to testify live, that witness should be presented in a video format, that the testimony should not just be read to the jury. So technology plays a big impact on how the millennial juror consumes information, so it'll translate into the courtroom as to how the millennial juror consumes that specific case. Another thing is a big presence in social media. So a millennial juror would be aware of all these cases and big verdicts that are coming out. They might see them on social media. They might already have a kind of preconceived notion or almost already an anchor in their brain just from seeing all of these big news stories come out.
So there's been many causes and repercussions as well as consequences resulting from the increase of these nuclear verdicts. Probably the biggest and greatest repercussion is in the trucking industry, with commercial insurance rates increasing by 20 to 25%. As a result of those increases in insurance rates, the deductibles have also increased, requiring companies to pay more in order to carry on their business. In addition to commercial insurance rates, umbrella or excess liability policies have also increased due to these nuclear verdicts and the high cost of defending and litigating them. Just over 75% have increased in purchasing, which have caused trucking companies to purchase less insurance and driving some smaller companies out of the market entirely. Federal law requires trucks and trucking industries to carry a minimum of $750,000 in liability limits, which as of late is not enough to cover the cost of these huge jury verdicts and nuclear verdicts. So lots of smaller companies have had to purchase other means of insurance or just opt out of the business entirely. As a result, trucking companies have tried to mitigate these costs by passing them on to their customers through higher shipping rates and higher product prices, and trying to pass on these expenses to the customers themselves so that they can stay in the market and carry on their business. Another consequence from these nuclear verdicts have been the Texas House Bill 19, which was passed recently on a bipartisan basis by the Texas House. And what it does is it bifurcates the trial process into two phases. The first phase focuses on the driver's liability itself and his or her fault, as well as what they were doing at the time. It's very largely individualistic, where it looks at solely his or her conduct at the time of the accident, and it excludes any allegations or evidence of unsafe practices. And in many cases, the jury might not even know the name of the motor carrier or the company that owns the convoy and the trucking hauling company. The second phase is largely focusing on the carrier's liability. So that's when allegations of respondeat superior will come in, and it'll be focused on the carrier itself, whoever owns the company, their practices, and punitive damages, if any. This bifurcated trial process is not automatic. the parties have to request the trial process by motion within 120 days after the defendant's response to the petition. And largely what it attempts to do is to mitigate some of these reptile tactics that Eric was talking about earlier by segregating the driver's liability from the carrier's liability, because the reptilian tactics will typically be focused on the carrier's liability and an attempt to vilify the company that owns the motor vehicle and the convoy and whatever they're hauling at that time. So another thing that the House bill does is limit the admissibility of evidence, primarily by limiting the introduction of evidence that the motor carrier did not efficiently meet the federal compliance laws, such as the FMCA, Federal Motor Carrier Safety Administration regulations, which have several standards, minimum standards that carriers must abide by. The only way this evidence gets introduced is by meeting two very narrow and specific criteria. The first being that the parties must show that the regulation or law that the motor vehicle did not comply with was the direct cause of the accident. The second criteria that plaintiffs must meet in order to introduce this kind of evidence is that the compliance law must have been the cause and causative conduct and been an element of the duty of care that is involved in the lawsuit. If the plaintiff is successful in introducing this evidence, more evidence of similar failures to comply with the federal regulations may be admitted, but only if such evidence occurred within 2 years of the accident. So all in all, House Bill 19 has been drafted to largely curtail some of those reptilian tactics. And again, it was a bipartisan bill that was easily passed in the legislature. So now we're going to go into some of the most recent verdicts that have that qualify as nuclear verdicts in this past year. To start off, we looked at the Ramsey versus Landstar Ranger lawsuit, which occurred in Titus County, Texas this year. And it involved a 73-year-old great-grandmother who was driving in Titus, Texas. And what happened was that Landstar Ranger was hauling a 16.5-foot wide submarine propeller for the Navy. And they were escorted by 2A pilot cars in front and in the rear by S&M pilot cars. So they were going on this 1,000-foot bridge in Titus County. And what the plaintiffs allege should have been done was the pilot car should have driven, the one in the front should have driven ahead of all of the other convoy vehicles and alerted the other convoy vehicles of any oncoming traffic or cars so that they can be aware and take precautions. But according to the plaintiff, they didn't do that. And so when Miss Tombest, the 7-year-old grandmother, was driving on the bridge, the vehicles didn't see each other, and at a 63 miles per hour pace, didn't have enough time to avoid the other. So the submarine propeller actually took off the whole front part of Miss Tombest's car, causing her to die instantly at the site of the crash. The plaintiffs argued that the regulations were not complied with and that the minimum safety standards were also not complied with, and that the blind spot could have been avoided if the pilot car had properly complied with the standard regulations. What happened was, prior to trial, though, the Florida-based Landstar Ranger actually settled with the plaintiff for $50 million. And the S&M pilot service, which was the pilot service on the back of the carrier, settled for $1 million respectively. And so the jury actually still allocated liability 20% to Landstar and 30% to S&M Pilot Service, although the total was $730 million at the end of the day towards 2A pilot cars, which did not settle prior to trial. During trial, 2A pilot cars was impeached about 14 times based on her prior deposition testimony. During trial, she also admitted that she violated best practices and admitted that she was driving recklessly, which allowed plaintiffs to kind of latch on to exemplary damages. And according to an article by Louis Brisbois, the verdict was awarded for $730 million, and $480 million were compensatory damages, and $250 million were punitive damages. The article also mentioned that there were several possible reptilian tactics that were used by plaintiffs' counsel as well. Primarily that the plaintiffs asked the jury during trial to send a message to the industry and to big business through its verdict. So that might have encouraged the nuclear verdict, as well as plaintiffs using allegedly fictitious industry standards or best practices concepts that were allowed to be introduced into trial, particularly in cross-examination. Another recent nuclear verdict that occurred this year was Kelli Most versus Team Industrial Services in Fort Bend County. And this one was a case that involved the widow, or Kelli Most is the widow of Jesse Most, or Jesse Henson, who worked at a Team Industrial Services energy plant in Fort Bend County, which is a coal-fired power plant that converts chemical energy into electricity. And the way they do that is through these massive steam turbines. So what happened to Kelli Most's husband was that he was working on these steam turbines, and there was a defect in the steam turbine, which caused the hot steam to be released unexpectedly. And he died from the burns that occurred because of that. And so plaintiffs filed a cause of action in Fort Bend County for alleging products liability from the design and manufacture of the steam turbine that was defected, and which caused the plaintiff's injuries and deaths. Breach of warranty and negligence per se, and gross negligence. During trial, the plaintiff showed evidence that the Team Industrial Services was actually aware of a faulty release vessel in the steam turbine, and they introduced evidence also that the defendant suspected that it might fail, according to a press release. The verdict was for $222 million, and the jury found that Team was 90% responsible for the incident, and Westar Energy, the owner of the Jefferson plant, was only 10% responsible for the death of Jesse Henson. To break down that verdict a little bit, it was $27 million for physical pain, $30 million for mental anguish, and $75 million for loss of companionship, and $90 million for past and future mental anguish. According to plaintiff's counsel in an interview, he said that another similar trend, which Ericka hinted at, that they sent a message to the industry through the jury's verdict. And he said that it was loud and clear that human life matters, and that big companies cannot avoid the responsibility of deadly workplace disasters. So with that mindset, that may have been a contributing factor for such a large jury verdict at the end of the day. Shifting gears a little bit, another recent case that came out of the federal court, actually, in I think the Western Division, was the VLSI technology against Intel Corporation. And this case involved a patent infringement lawsuit where VLSI alleged that the defendants, Intel Corporation, were using 2 of its speed shifting patents. And those patents have to do with the speed of processors, which is a key issue in that industry for competition of those speed processors. Through the pleadings and in trial, plaintiffs tried to allege that the defendants were accused of willful blindness. Federal law and patent litigation doesn't require someone to know of a patent to be found to be able to infringe on it. However, the jury did not find willful blindness, which would have caused the jury verdict to actually have been tripled. So it would have been 3 times that amount. After the $2.8 billion jury verdict, Intel's stock actually fell 2.6% in the New York stock trading. And to kind of put it in perspective with these tech companies, while 2.8 billion might be a lot to a normal person, the defendant paid, I think, a few years prior to Micro Unity Systems Engineering Corporation $300 million for a patent, and paid another corporation $1.5 billion. So while these verdicts seem large for trucking industry, it might be more typical in patent infringement cases. Some litigation tactics that plaintiffs use and were successful using was that VLSI was accused of being using egregious litigation tactics and shielding evidence, as well as advancing not so stable infringement theories, but that was responded to by VLSI in an interview that they did have routine and perfectly appropriate practices. So it's unclear whether reptilian tactics were used in this case, but the plaintiffs were successful in the tactics that they did use. And some food for thought after the verdict was that VLSI is a non-practicing entity, which, going back to the factors that contribute to nuclear verdicts, is a form of financing for litigation, in that they're part of a hedge fund, which is called Fortress Investment Group. Or I apologize. It's actually called it's called Fortress Investment Group, which invests in litigation and may have an interest in the outcome of the lawsuit, and relies on patent litigation for its revenue and as its business model. So that was our case.
We're also looking at Cruz versus Allied Aviation Fueling Company of Houston. The verdict in this case was about $353 million. It came out of Harris County recently, I believe in October. The facts of this case: Mr. Cruz was a wing walker, so kind of walks along the moving jets at the airport here at Bush International. They kind of notify those around them that the airplane is moving and kind of make way for the airplane. Mr. Cruz was acting as a wing walker. When the airplane was moving backwards, he was walking alongside it when the driver from Allied Aviation Fueling Company did not stop, did not see him, and basically hit him. He suffered severe injuries. He was paralyzed and then suffered a subsequent stroke as a result of those injuries. What the driver said basically was that he could not see because the sun was in his eyes. It was early in the morning and the sun was coming up and he was driving directly into it. Allied Aviation admitted that the driver should not have been driven and have been driving if he couldn't see that the driver should have stopped and should not have kept going, and that he did not follow policies. The jury found in that case that the company was 70% responsible and the driver was 30% responsible. One factor that might be attributed to that is that the driver was still employed with the company during the trial. This is a breakdown of the verdict. I was about 35 million for economic damages, and about 10 times that, 317 million for non-economic damages. Another interesting thing about this is that the plaintiff did not ask for punitive damages, so that a unanimous decision was not needed. Rather of asking for punitive damages to send a message, it was focused more on the non-economic damages of the plaintiff. The trial lasted about 2 weeks. Another case is Cargal versus FedEx. Sofia has mentioned that the trucking companies have been specifically dealing with a lot of these large verdicts recently. This one's another one. The verdict in this case was 30 million. It was also here in Harris County. The facts of the case is that the plaintiff, Joseph Cargal, was driving his tractor early in the morning on September 8th when the FedEx truck was being driven on the opposite side of the street. A branch or a tree fell in front of the FedEx truck, and the FedEx truck swerved into incoming traffic and hit plaintiff's truck head on, and the plaintiff died at the scene. The lawsuit was filed by his 2 sons. The trial lasted about 10 days. Plaintiff alleged that FedEx was negligent in training and in supervising the driver because he was not instructed to stay on the road, to not swerve into oncoming traffic, or he was not properly instructed as to what should be done whenever he approached that fallen limb on the road. During the investigation, it was also found that the driver was actually going over the speed limit. It was a rainy day and it was low visibility conditions, so he was also found negligent. I believe he was found 49% to be at fault and FedEx to be 51% at fault. And this was the breakdown of the verdict. Each son got 15 million, and those were in pecuniary loss, loss of companionship, and mental anguish. One thing that was interesting in this case was that in interviews with plaintiff's counsel and with plaintiff, that reptile tactic of sending a message was front and center. Plaintiff said that his goal was to motivate trucking companies to improve their safety procedures. And plaintiff's counsel said that it was the lack of training and the lack of supervision that contributed to the accident, much more than the driver. Last, I'll talk about ACS, primary care physicians versus Molina Healthcare. The verdict here was 19.1 million in damages from Harris County. This case came out of Harris County. The plaintiff was a physicians group. They argued that Molina Healthcare routinely underpaid their claims, that they violated insurance laws that require them to pay the usual and customary rates for the geographic area. The jury agreed. They awarded 19.1 million in damages. This case had a lot of reptile theory tactics and themes in it. Jurors were told that this case was being watched nationally by emergency room doctors and by insurance companies. They were told that this was the first case in the nation to litigate this issue, and they were told that they are the, quote, the tip of the spear. They were basically told to send a message with this case. We also saw the anchoring effect. At closing, plaintiff asked for 17.4 million and for the underpayment, and he also asked for 100 million and punitive damages. The jury came back with 1.58 million in actual damages and 17.5 million in punitive damages, meaning they were most likely trying to send that message that plaintiff asked them to send. With that, it's all we have, and we'll open it up for any questions. If not, I want to thank Daniel and thank HYLA for having us on the CLE.
Thanks for having us.
Would give them just a few minutes to have the questions come in. So if you're not familiar with how to do this at this format, we have a Q&A function where you can post questions if you have any questions. So we'll just give you a few minutes in case anyone has anything.
And this may have been announced when I was talking to the mediator, but the MCLE number is going to be emailed to everybody by Lucy. So we don't currently have the MCLE number, but check your email and it'll go out to all attendees. So we apologize, we don't have that right now. We have a question in the chat.
Books.
Yeah. The book
The Reptile
Maria may be talking about is the Reptile Theory book. It was called Manual of the Plaintiff's Revolution by David Ball and Don Keenan. It's largely accredited with bringing this reptile theory into the context of litigation, and some believe these verdicts have gone up since 2009, which is when the book was published. Outside of that, I don't have any other specific recommendations. The reptile theory has been written about and discussed at length because people attribute these large verdicts to it. So there's plenty online and research-wise as well.
There's just adding on to that, there's another very good article actually published by Bill Kanaski, and I'll put it in the chat, called DRI for the Defense Litigation Skills, Old Wine, New Bottles, the Nuclear Verdict. And it kind of just explains everything we mentioned in greater detail, as well as includes some studies that have graphics and numbers so that you can go into that a little bit deeper if you'd like.
Thank you.
Thank you.
I'm not sure.
I'm not entirely sure
Mhm.
whether they've structured insurance towers or how it's affected underwriting specifically. All we know based on what we've looked into is that the rates have increased. But that's an interesting question and definitely worthy of looking into.
It's a question about the CLE number. Lucy is going to be sending that out to all the registered attendees after the event. So we don't have the CLE number right now. So we appreciate your patience, but I'll be coming to you quickly. Thank you. Okay, it looks like those are all the questions we have. So we want to thank you, Ericka and Sofia, again for this outstanding presentation. And all the attendees, we want to thank you as well for sharing your afternoon with us. We hope you'll join us for the next CLE. Thank you.
Thanks,
Thank you,
Daniel.
everyone.
Thanks for dropping by.
Finally.